Okay, good morning, everyone, and welcome to our webinar today on covenant enforcements by Steve Rappaport. He is with the attorney firm Sachs and Kaplan. We also have today our moderator is Beth Garcia. Beth is with Brown and Brown Insurance. And I just want to introduce myself. I'm Peggy West. I'm the organizer of the webinar. And before I get into introducing our sponsors who invited you, let's do a little bit of housekeeping. I want to say that my hat is off to most or all the board members that are on today because all the law changes recently and just even thinking about covenant enforcement, a lot of new board members here are going to have to learn some of these tricks to manage all the crowd and the residents and everything. And Steve is excellent at presenting pointers. So this is going to be recorded. And we are going to record your questions and answers in case we don't get to them today or Steve doesn't get to them. So would you please enter your email after your question, just in case he needs to answer you directly on a private email. If you need to put your question in, please put it only in the Q&A box and not in the chat box. The chat box is just for comments, which the sponsors will probably put their contact information into. And at the end of the webinar, as usual, I'll be sending out a sponsor sheet, and the sponsor sheet will have everyone's name, title, email, and phone number. So please, if you would, use them for resources. So let's get into it. Steve's got some great information to share. Starting with the sponsors, I want to first introduce Vinteum software. This is the wind beneath my wings for all your IT support. And we have today Katie Bassford on. She's our national sales manager for them. And Katie, tell us about yourself, what you do, and what does Vinteum do for associations?
Yeah, thank you so much, Peggy. Vinteum provides Neighbors for associations, which is an all-in-one platform that improves communication and transparency for community associations. And especially in Florida, we can help you stay compliant with those upcoming website laws that Peggy mentioned. So if you are curious to learn more about the software, as Peggy mentioned, I am the national sales manager. So I work with clients all across the US. I would love to get a demo scheduled or just answer any questions you have about the software. So please feel free to reach out.
Awesome. Thank you, Katie. And now, if you haven't heard and you're a new board member, if you have 25 units or more, you are required by law now to have a platform for uh, just all your information, finances. You can store your architectural things, your newsletters, anything for your website. So check into them. I use them and have used them for years now, over 5 years, and highly recommend them. Okay, next I want to make honorable mention of their new marketing manager, Hector. I'm sorry, Hercules. Sorry about that. And also
Close enough.
Tiago. Yes, okay. So if you guys will wave, if you want to say a few words, you can.
Well, I want to say thank you for inviting me, for being here. It's always a pleasure to join and learn from you guys. So thank you.
Okay. All right, next I want to introduce Beth Garcia. She is the Senior Vice President for Brown and Brown Insurance and today's moderator. They have specialties for condos and homeowner associations. Beth, tell us about that and yourself, please.
Hi, good morning. Thank you everyone for being here. My name is Beth Garcia Swope. I'm with Brown and Brown Insurance. I'm a Senior Vice President. I'm actually a 33-year agent, but I've been with Brown and Brown for going on 14 years now. We specialize within associations we're located, my office is located in Fort Lauderdale. We are founded in Daytona, but we are a national company and international, traded on the New York Stock Exchange. Within our Fort Lauderdale office, we actually insure more condominiums and associations than any other office. So we do have all the relationships needed in order to help you find some options available. We're kind of coming out of a disastrous 3 years with insurance. I'm not going to say it's where it used to be 5 years ago, but we're getting a little closer with some of the changes that are taking place legislatively. While I know it's been creating an issue on the association side, if you want to reach out to us, we can kind of help you maneuver some of that changes that have taken place within your insurance program.
Awesome. Okay. Again, her number will be on the sponsor sheet for reference to get maybe even just look at your policy for an evaluation. Next, I want to introduce a longtime industry contact for me and friend, Jamie Gelfand. She is the Vice President and Regional Sales Officer in Southeast Florida for First Citizens Bank. JC, tell us about the bank.
Good morning, Peggy and crew. It's a happy Wednesday to everybody. I want to thank you for the opportunity to present First Citizens Bank. We are a 125-year-old top 20 bank in the CAB Community Association Banking Division. We provide lockbox services for management companies, as well as loans for either self-managed associations or management companies for all of your upcoming milestone requirements. So if I can be of any assistance, I will put my information in the chat. Hope you enjoy Steve's class.
Okay, great, thanks, Jamie. Thank you. Okay, next I want to introduce Bob Aleka. He's a Vice President for Faster IO. Bob, you're a new company to the area, so tell everybody your news about what you're doing.
Well, good morning, all. Bob Aleka here with Faster IO. Faster IO provides streaming TV, internet to condominiums and HOAs through our fiber optic system. We've been around for about 20 years as a data center. So we're in the back end for all of these government, financial, insurance, healthcare, telecommunication companies. We've been building fiber optic infrastructures for these telecommunication companies, managing them and bringing them back to the data center where they house all their equipment. We are now in front of this, and we're providing infrastructures, streaming TV to condominiums and HOAs. So if you have, if you're in 2 years or somewhere in that neighborhood of your current contract, give me a shout. I'll be more than happy to tell you how we do things, how we build things, and what really makes us totally different from everybody else out there through our 20 years of experience of being a data center. I'll put my information in the chat and enjoy Steve's class. Thanks.
Great, thank you and good luck. Okay, yeah, next I have, again, another longtime industry contact, Rudy Forehand. He's a regional manager for Benjamin Moore Paints. Say hello and tell us what you do.
Terrific. Good morning, everyone. Thanks for attending. Rudy Forehand with Benjamin Moore Paints. I've got 35 years with the company down here in South Florida, and we sell paint, but we do more than just sell you a can of paint. We sell you the service and the know-how on how to put that paint and to do that paint, put that paint on your properties, especially with all the projects that are going on. Painting is one of the biggest projects that you have in your community. And we assist you in making sure that we give you the power, so to speak, when working with contractors, to have the answers before the question is asked, so that you know how to separate the contractors that are telling you and wanting to work with you and not. We kind of almost become pseudo project managers for you. So if you need assistance, we do everything from color renderings to color consultation, on-site inspections, forensics of paint, and so forth, and recommendations of paint and contractors. So if you need anything like that along that route, feel free to reach out to me. I cover all the way from Vero Beach all the way down to Miami. So let me know if you have any questions, and I'll put my information in the chat. And I'd love to be able to work with you in your community, and we'll get you the best job possible for the best value you're going to get. So thank you, everybody. Enjoy the seminar.
Very good. Thank you so much, Rudy. Okay, next I skipped over by mistake. Brooke, would you like to go on and introduce yourself? And she's with Southwest Elevators, and she does cover all of Florida, so she's on the run today.
Thanks, Peggy. My name is Brooke. I'm with Southwest Elevator, which is a family-owned and operated elevator company. I'm actually the 4th generation stepping in, so we've been around for quite some time. We specialize in elevator maintenance, repair, and modernization. So any elevator needs that you would need at any of your buildings, I would love to be a resource for you, and I will put my contact info in the chat box. Thank you.
Okay, great. Thank you and good luck today. Okay, next I'm going to introduce Daniel Baum. He's the founder and the CEO for COA Solutions of Florida. He's working in the commercial property and casualty insurance. He's a specialist. And tell us about yourself and what your company is doing. You do some different things.
Thank you, Peggy. Good morning, everybody. Appreciate you having me on today. So I specialize in commercial property and casualty insurance, much like Brown & Brown. I look at my responsibility to my communities and my clients as trying to help them in every way possible to reduce the cost of insurance. It's obviously gotten out of hand for a lot of people. We're entering budget season. Everyone's freaking out about what their budgets are. And while the increases haven't been quite as dramatic as they have been the last couple of years, nobody wants an increase on their insurance. Not me, not you, not any of us. So in my opinion, the role of an insurance broker is to help our communities by finding alternative options, being proactive, guiding them on what steps they can take in order to try to reduce that insurance cost, both for the property and casualty policies, and shopping it well in advance of renewal dates so that we can find whatever alternatives are out there. God willing, we won't have any major hurricanes in the next few months, and the market will come back to its senses a little bit, and we'll have a much more open and opportunistic market going into 2025, which would be very helpful for everyone. The last thing I'll say is I do a complimentary review of anyone's policies that they might like me to take a look at and see if there is savings to be had. There's nothing to sign. I don't ask you to sign any letters. There's no documentation. It's a pretty simple and straightforward process, and pretty quickly I can tell you if you're paying a reasonable rate or if I think you're paying above what you should be, and there's other options out there. So with that said, I wish you all a wonderful day. Enjoy the webinar, and thank you.
Okay, you're welcome, and thank you. Okay, next I want to mention a couple of the sponsors that are not on today, but do an outstanding job in the industry, starting with Hafer Company. The partner, Nicole Johnson Pendergrass, couldn't make it today. She's also the operations manager. They have 4 offices around the state, and they do an outstanding job, especially in the auditing area. So give them a call. They will be on the sponsor sheet. The next one I want to introduce is Best Roofing. Diana Alert couldn't be on today. She is a senior business development manager. She's been with them for over 10 years and does an outstanding job getting you roofing evaluations and scheduling meetings. So her info will also be on that. Munyon Painting is also out on appointments today. Chris Clark is the marketing manager for them. He covers all of Florida, and they have been adding some more people. So when you call him, he's not going to be so stretched, and maybe they'll get to you a little bit sooner. So reach out to them. And lastly, I'll mention that I do work for Beach and Patio Outdoor Living myself. We are a full service patio and pool deck company. We can provide you new furniture, but we also have an excellent reputation in quality repair work where we restrap and refinish. And we've been around over 50 years, and the owners are outstanding. So great people to work with. Call me, I'll give you a great proposal. So with that, I'm going to turn it back over to Beth Garcia Swopa, our moderator, to do the next introduction, and then Steve into the class. Take it away.
Thank you, Peggy. Stephen Rappaport is a seasoned community association attorney with 19 years experience. He has successfully handled legal matters for hundreds of community associations, many complex and high profile. He incorporates his extensive legal knowledge with his passionate dedication to providing his clients a high level service in order to best meet their needs. Mr. Rappaport obtained his Juris Doctorate from Georgetown University in 2001. He is a member of the Florida Bar, the District of Columbia Bar, the Palm Beach Bar, and a board member of the South Palm Beach County Bar. He's also a delegate to the Florida Legislative Alliance for CIA and a director of Palm Beach County Fair Housing and Equal Employment Board. He began his career in Washington, D.C. as an associate at Wiley, Rain and Fielding before returning to his home in the state of Florida. and joined Sachs Kaplan, where he is now a partner in the Community Association Practice Group. He handles transactional matters for the firm's community association clients, including drafting amendments to governing documents, attending board meetings and elections, handling covenant enforcement disputes, and providing opinions on all aspects of association issues. Steve is a resolution-oriented attorney dedicated to providing personalized and accessible service to his clients. He enjoys speaking engagements and regularly conducts board certifications as well as seminars on high-level legal updates, emotional support animals, fair housing issues, and covenant enforcement and document amendments. Thank you for everything you do for the association, Steve, and we look forward to hearing what you have to say.
Well, thank you, Beth. Thank you, Peggy. Thank you to all of our sponsors. Whoever wrote that did a really amazing job. It sounds, I think, a lot more impressive than it actually is, but thank you for that. We're going to talk a little bit about covenant enforcement today. Everything you need to know in about 45 or 50 minutes or so on how to enforce your documents. But I want to get started, and it kind of seems sort of an obvious point, but we really need to begin at the beginning, which is, what is a covenant? What is a rule? What are the differences between your covenants and your rules? And more importantly, the first question you should always be asking is this really even a violation? Do we actually even have something that's on record being violated? And that's always the starting point. And it sounds obvious, but it isn't. And when you're a 720 HOA or a 718 condo association, and I'm presuming that most everybody here is either a homeowners association or a condo. So when I get to certain issues where there are differences, I'll do my best to focus in on what's different about the HOA law versus the condominium law. But when you're a 720 or a 718 and you're trying to enforce your documents, whether it's fining, whether it's suspending use rights, which we'll get into, or whether it's filing lawsuits, you need to make sure you have something in your governing documents that's being violated. You know, if you're a private country club, it's a lot different. You know, and we represent a few country clubs here, and we get calls all the time. You know, so-and-so called me a bad name on the tennis court. I want to send them to grievance. And in a country club, you can do that. That's normal standard operating procedures, because in a country club, you have rules, you have grievance procedures. You're not governed by 720 or 718 most of the time, unless you're a merged country club, and that's not the topic for today's discussion. But the point is, if you're a country club, you're going to get away with a lot more stuff than if you're an HOA or a condominium. So when you're in the 720 and the 718 world, you always need to start off with, what am I trying to enforce? What is the actual violation? Is there something in our documents that's actually being violated? Okay, so that's the starting point. Let's assume that there is something that we're looking at that's in our documents. The next question is going to be where. Where in the documents are we looking? What is it that we're trying to enforce? Is it a rule? Is it a declaration provision? Is it an architectural guideline? What is the nature of the violation, and where are we looking to it? Because if you're talking about a declaration provision, then that's going to be deemed to be valid and enforceable under Florida law, which is why we want most of our restrictions to be in the declaration in the first place, if we can get it there. If you have rules and regulations, that's great. We like rules and regulations because the board usually has the right to change those or adopt them from time to time without having to go to a vote of the membership. But the problem with rules is, number one, they're not deemed valid and enforceable like a declaration provision. They're judged on a reasonableness standard. So if somebody can argue that your rule is not reasonable, they'll have a better chance of getting around your enforcement mechanism than they would if you're talking about a declaration provision. The more important issue is your rule may conflict with something in the declaration, and because your declaration is a superior document, that's the one that's going to control. Remember, your declaration of restrictions, or if you're a condo, your declaration of condominium, it's sort of like your constitution. It's the most important document. It's usually the hardest to amend, but it's sort of like your constitution. It's what governs the use of the land. It's your most important document. So we want to try to get our restrictions into the declaration if we can. We want to try to hope that we're enforcing a declaration provision as opposed to the rules. But if we're looking at a rule, then number one, again, we need to make sure the rule is reasonable, and we need to make sure that it's not in conflict with something in a higher document. So for example, let's say we're trying to enforce a leasing restriction that says your lease can't be for less than 1 year or for 6 months. And that's in a rule. Well, let me look at the declaration, because I'm sure there's some language in the declaration that may conflict with that. And it might not even be what you think it is. It could just be, there might be nothing in your declaration on leasing restrictions, but take a look at your easement section in your declaration. I'll bet there's some very broad language in there that says that this property is for the use of the owners and their tenants, guests, and invitees, something along those lines. It's very common language in a declaration. If you have language granting an easement right in your declaration and it talks about rights of tenants without any further restrictions, and you try to now restrict tenants and leasing in your rules, that could be a problem. That could be viewed as a conflict between the rule and the declaration, which doesn't restrict leasing and actually provides very broad easement rights for your tenants and your guests and invitees. So that's sort of point number two. Number one, are we actually enforcing some sort of covenant or rule? And number two, we need to make sure if it's a rule, does it conflict with something in our declaration? Now, if we get to that point, we realize, well, we might have a conflict with our rule, or we might not have a rule or a declaration provision in place. What do we do? And that's where we talk about the amendment process. And what we want to do is we want to try to get our restrictions into our declaration. So keeping in mind that if we're talking about trying to adopt rules, that's usually a board vote. Usually the board has the right to adopt rules and regulations. And that might work fine for things like alternate side of the street parking, which we might talk about a little bit about later in the presentation, or that might work well with rules regarding the use of the swimming pool or things like that, clubhouse rules, gym rules. Those are typical things for your rules and regulations. But if you want to control leasing, if you want to control the types of vehicles that are parked on the property, if you want to control the ability to sell your property, if you want to have restrictions on criminal background and a screening process, things like that, I believe you really need to try to put those more important, more substantive restrictions in your declaration. And chances are you're going to require a 2/3 or maybe even a greater vote to amend your declaration. So you want to look at the declaration, realizing that each one of your documents has a different procedure for amendments. Again, most of the time your declaration will require a super majority vote, but you want to look at it. Does it require a 2/3 vote? Does it require a majority vote? Does it require a vote of just the members voting? Does it say 2/3 of the owners present and voting at a duly called meeting? Or does it say 2/3 of the entire voting interest or the entire membership? It's going to be a lot harder to amend your documents if it's a percentage of your entire membership versus just a percentage of those that are voting. And all you have to do is establish a quorum and get 2/3 of the quorum. So you want to look very carefully at your amendment language. You want to look very carefully at language about how you can go about doing an amendment. Do you need to call a meeting? What's the notice requirements? Or can you act by written consent in lieu of a meeting? That's always a great option if you need a 2/3 or 3/4 vote of the entire membership. Chapter 617, which governs all not-for-profit corporations, has a procedure called written consent in lieu of a meeting where you can basically mail out or email out, for those who've consented to emails, a written consent ballot or consent vote to vote on the amendment. And it gives you a better chance of controlling the process. It allows you to send the vote out by mail, by hand delivery, by e-blast. It gives you a 90-day window of time to be able to amend your documents. So that's a procedure that we like to use if the documents allow us to use that procedure. It helps us reach more owners and gives us a better process to make it more likely to amend our documents. I do want to point out one thing when we're talking about amendments before I talk about covenant enforcement in general, and that's on leasing. So we need, again, going back to the beginning, want to make sure we have a covenant in place. If we don't have a covenant in place, we want to try to amend the documents to put a covenant in place or something in place that is enforceable. When it comes to leasing, though, there's a special carve out for that, and it's a little bit different for condominiums and for HOAs, because of course the legislature wouldn't put the same language in the two statutes. So if you're doing a leasing restriction as a condominium, there is a provision in 718 that says that certain types of leasing restrictions, prohibiting leasing, changing the number of times you can lease in a given year, or changing the minimum lease terms, those types of leasing amendments will only apply to those people who vote for them or who take title to their units after they go into effect. So it's almost like a statutory grandfathering, an extra protection on leasing. Again, this is leasing only, so this has nothing to do with pet restrictions or vehicle restrictions or anything like that. So if you're a condominium and you're trying to do those types of leasing restrictions, you need to be aware that there might be some protections for existing owners who don't vote in favor of them. Now, on the HOA side, as of 2021, the legislature put in similar language for HOAs, but of course not identical. What the HOA law says is that any amendment that regulates leasing agreements will only apply to those who vote for them or those who purchase or take title after they go into effect, except for certain restrictions on short-term rentals. The HOA law allows you to restrict short-term rentals. I believe it's of less than 6 months or no more than 3 times a year, and that will apply to everybody, regardless of whether they vote for it or against it, or whether they're an existing owner or not. So it's almost sort of the reverse, which is a little bizarre and strange that they did this. But for condos, most leasing restrictions will apply to everybody's except for those specific 3 restrictions that's listed in the statute. And for HOAs, just about every rental restriction won't apply to the existing owners, but they do have a carve out for short-term rental restrictions. Very strange, but again, I think the take-home lesson is make sure you speak with your association attorney when you're thinking about doing rental restrictions, because number one, you're going to need help drafting them, but number two, you want to have a strategy to help make sure that they get put into place properly, but also so that you know who they're going to apply to and who they may not apply to. If you're leasing, a great question. If your leasing amendment was done before the 2021 law, then you'll be fine, because the law wasn't in effect at that time. So all your pre-2021 leasing restrictions for an HOA are perfectly fine. It's if you're looking to do them now, or if you've done them after 2021 when that law went into effect. And that's a little bit questionable, because we'll talk at the very end, if we have some time, about Kaufman language and how that affects all these statutory changes as well. But moving on, again, want to have a covenant in place, need to make sure we understand whether it's in your rules versus your declaration. If it's in your rule and it's a conflict, or you don't have anything, we want to make sure to amend the documents to properly put it into place. Okay, so assuming we've done all that, assuming we have an ironclad restriction, it's in the declaration, or we've got it amended to put it into the declaration, someone violates it. What do we do? That's the purpose of this course, covenant enforcement. How do we enforce our covenants? What do we do next? Management drives around, they notice a violation, they come back to the board and say, hey, so-and-so is in violation, what do we do? To me, first step is never get on the phone with and I realize this is against my own interest, but never get on the phone with the attorney right away. Okay, for the most part, remember, your neighbors, this is your community, this is where you as a board member or a manager either have to live or have to work for a good portion of the near future, maybe beyond the near future. So my recommendation is always have a conversation first. Again, depending on whether the person's reasonable, whether this person is somebody that is known to be a violator, but assuming it's a first-time thing or somebody that you know to be a decent person, have the conversation first. Many times they don't even know they're in violation. They weren't aware of the rule. They didn't realize something was wrong. I think it's always important. Your first step is have that conversation, talk to the person, point out the issue, try to resolve it without even having to send a letter or going to the attorneys. I would bet more than half of your violations would get resolved through those means without even getting into any formalities. Assuming that doesn't work, I think most associations, most management companies have some form of anywhere from 1 to 3 letters that they send, usually a warning letter, a friendly warning letter, violation letter at first. You don't want to come out of the gates with a threat to litigate the issue. So I think a friendly letter, we're here to enforce the documents. Enforcing the documents is good for our property values. You may or may not be aware that you're in violation. Please have this rectified within 30 days. We're doing this for the betterment of the community. Thank you for your attention to this important matter.
Hey,
I think
Steve, there's one quick question. A couple of people asked, can you define covenant?
A covenant is sort of like a contract. The legal term of art is covenant running with the land. So as opposed to a rule, which is basically just a policy or a procedure, a covenant actually binds the land. Your declaration, if you're a HOA, declaration of restrictions, declaration of covenants, declaration of protective covenants, whatever the name that your declaration uses, or if you're a condominium, it's 99% of the time a declaration of condominium. That is a binding contract on the use of the land. It actually runs with the land. So when you sell your property, that property is subject to that declaration. It's not just a rule that can be changed. It's not just a contract that's between two parties. It actually binds the use of the property itself. It runs with the land, and that's what a covenant truly is.
Okay. And then someone asked, if leasing was amended prior to 2021 in an HOA, do they apply to all?
Yes, in that situation prior to 2021, your leasing amendment will still be valid as to everybody because it was put into place prior to the change in the law. Okay.
Thank
And
you.
when we talk, I'm sure we'll have a little time at the end to talk about Kaufman language. The whole idea of Kaufman language is that you can't retroactively apply a statute or a law to an existing contract. And so that's why the pre-2021 amendments will be fine, because they predated the change in the statute. Okay, so moving forward with how do we actually enforce the covenants? Again, sending out a warning letter, a friendly warning letter, having a conversation, those are all good first steps. If that gets you nowhere, usually a second stronger violation letter is typical for most associations, maybe giving a shorter time frame, maybe threatening that it might be turned over to the lawyer if something isn't done in a certain amount of time, threatening additional fines or suspensions. That's usually the topic, the way a second letter I think is well structured. And I think that usually will resolve the issue. They know you're serious, but again, you're not spending tons of money. You're not going to the lawyer yet. hopefully 70–80% of the violations get taken care of either through talking it out with the person, sending 1 or 2 letters, making sure they know you're serious. But if it doesn't get resolved at that point, what are our next options? And these are all options that are all, you don't have to choose one versus the other. I mean, these are all options that you can do all at the same time, or you can do one or the other, but you have the right to levy fines. You have the right to levy suspensions of common area use rights, and you have the right to litigate, go to court, where you have to go to mediation first, but you have the right to go to court to get an order from the court for the person to comply with the documents. Most of the time you start off with the fines and suspensions, and I want to talk a little bit about that process. And I want to talk really about the differences between condo and HOA, because there are some major differences between them. So when you're levying fines or suspensions, remember, for violations, a fine or a suspension can be levied by the board, but it has to be approved by an independent committee. And for both 718 and 720, it's an independent committee of at least 3 people, not officers, not directors, not employees of the association, not a relative of that person. A truly independent 3-person panel will then sit in a hearing and allow you to present your side of the case, will allow the association to present its side, and then that committee, their sole job is to vote up or down the fine. They're not there to negotiate the amount. They're not there to try to get you to comply with the documents. Their whole role is to just say yes or no on the fine or the suspension proposed by the board. Go ahead, Beth. Beth, you're muted, I think.
Sorry about that.
Okay, sure.
We have 2. What if no HOA has no fining fee for a violation and the homeowner continues to violate? Can we lien?
Possibly. I'm going to get to that in a second and talk about the lien rights versus the non-lien rights on your fine. So I'll get to that in a second.
Okay, and then what is your opinion on the revised parking language by the state of HOAs for the state for HOAs that do not have Kaufman language in their governing docs?
And I'll get to that also at the end when we talk a little bit about the Kaufman language. But there are, yes, for HOAs, there are going to be some types of restrictions that you are not able to enforce anymore if you have certain language in your documents that applies the new statute to you. But we'll talk about that a little bit later in the presentation. This is more just in general how we're enforcing the documents. And again, getting back to the fines and suspensions. So 720, 718, you both have the right to levy fines, both have the right to levy suspensions of use rights, both have to do it through an independent committee on a 14-day notice and a hearing provided by that committee. And the committee's sole job is to vote yes or no on the fines. Now, here's the important differences. Under 718, if you're a condominium association, number 1, you are not allowed to go above $100 per violation or per day of a violation by statute. So you're capped at a $100 per violation, and you're capped at $1,000 total aggregate for a continuing violation. So if somebody's continuing to violate the documents on a day-to-day basis, it's $100 a day up to $1,000, and that's all you can do as a condominium association. As a condominium association, you also cannot lien for a fine. So there really are no lien rights for penalties for violations in a condo association. HOA, a little bit different. HOA, if the fine is of $1,000 or more, you can lien for it if the documents have language allowing you to lien for that type of a charge. So you want to look to your documents to make sure the documents have some good lien language under your enforcement provisions. And if not, that's another area where I would recommend some amendments to give you that authority. But the statute in 720 also says that you're capped at the $100 or $1,000 unless otherwise provided in the governing document. So that language, unless otherwise provided, allows you to go into your documents and raise those amounts to a higher level. So you, as an HOA, could in theory go above $100 per day or $100 per violation. You could go to a $5,000 or $10,000 maximum aggregate for a continuing violation if your governing documents provide for that. If there's no fine, so the question, follow-up question is, if there's no fining committee, then that's correct. You cannot fine the unit owner. But this is a question I get all the time is, we don't have enough people to have a fining committee, so we can't enforce our documents. That's not the case. Remember, fining and suspensions are an alternate remedy. They're one of your many remedies. Doesn't mean you can't still force compliance with your documents or enforce your covenants if you don't have a fining committee. It just means you can't levy fines, which is important. It's good to have that fining authority, but that's only one of your remedies. It doesn't mean you can't go to mediation. It doesn't mean you can't send violation letters. It doesn't mean you can't contact the attorney and have the attorney send a violation letter or threaten to sue them for the violation. So the absence of a fining committee only means that you can't levy a dollar amount fine for the violation. Doesn't mean you can't enforce your documents. You still have all of your other statutory or document remedies for enforcing your documents. So levying of fines, again, your condominium very much restricted on what you can do. HOA, you can amend your documents if you haven't already to give yourself a little more authority to lean for the fines, to increase the threshold levels of fines. Okay, now beyond the fining, at that point, if that doesn't work, because the goal is compliance, the goal is not necessarily to make money. So even if they pay the fine and they haven't rectified the underlying violation, we still have work to do. There's still a violation on the property. So at that point, the statute allows you to go to court and to get an order to force the person to comply with the documents. And both under 718 and 720 now requires pre-suit mediation before we go to court. Condo, you can also do arbitration. I don't highly recommend it because it's through the division in Tallahassee. They're so backlogged, and 90% of the time they force you into mediation anyway. Something to discuss with your association's attorney, but more often than not, I recommend just going through the pre-suit mediation. A lot of times that does resolve the issue and you don't have to worry about going to court. But that's the bottom line, is for both a 720 and a 718. If you want to move forward to go into court to get an order for them to comply with the documents, you do need to offer pre-suit mediation. It's a process where you send a statutory letter to the owner. You give them a choice of 5 mediators. They have 20 days to respond, and then you have up to 90 days to mediate the case. If it doesn't resolve, if it's an impasse, or if they don't show up or they don't participate in the process, then you can go to court and seek your remedies through the court, in which case, if you are the prevailing party, you would be entitled to your fees and costs for bringing the lawsuit in the first place. Beth, do we have a few questions?
We
before
do.
move on? Okay.
If the owner rents a unit as a Airbnb when it's not permitted, maximum fine in a condo is $1,000 per year.
So the maximum fine for a condo is $1,000 for a continuing violation. So it's really not based on per year. What it says is for a continuing violation. So if they rent an Airbnb for 10 days and you fine them $100 a day for 10 days, that to me is your cap on that violation. If they come back 6 months later and they rent the property again for another 10 days in violation of the documents, I would argue that even if it's within the same calendar year or within 6 months or whatever it is, if it's a different rental and a different violation, I would argue that that's a new violation. You can fine additionally for that violation, but then you're still capped at that $100 up to $1,000 for that particular violation. So it's really a per violation or per continuing violation issue.
Okay. Can you force the lawyer's letter fee to owner?
Great question. We threaten it in our letters all the time. Whether we can really do it or not is kind of dependent on your documents. Chances are, as a condo, you probably can't, because under condo law, they're very tough about what you can charge for. And there's arguments about only being able to charge fees that are expressly permitted by statute. So usually the rule is pre-suit fees are not recoverable.
Milhares de perguntas no Q&A.
I don't know if Hercules is.
All right, Hercules, you're not on mute.
Sorry about that. So, generally pre-suit fees are not recoverable. Usually the prevailing party attorney fee is therefore once you file the lawsuit. Once you filed the lawsuit, then I think all your fees on a moving forward basis are recoverable. The lawyer letter, chances are it's not going to be. Now, you may have something in your documents that might talk about the ability to recover fees or charge for fees that are incurred pre-suit. That might be something to talk about with your association's attorney about doing maybe as an amendment. More likely to be successful in doing that as an HOA versus a condominium. But again, the general rule of law is recovering of fees usually is from a lawsuit forward as opposed to pre-suit. Okay. Oh, Beth, you're still on. Sorry
about that. Are the fining guidelines required to be posted on the website by October, or are they in the covenants and R&Rs?
Yeah, if you have written guidelines, that's a great question. There's really nothing in the statute that talks about fining guidelines, but if you've adopted a fining schedule, or if you have rules or procedures relating to fining that you've published or that you work off of, I would probably include those. I think whether it's required or not, I think it's a good idea, because I think the idea is you want to be transparent, and you want people to know what the rules are, what the covenants are, and what the penalties are going to be if you violate them. So I think it is actually a good idea to post those things on your website if you're required to.
Okay. I don't know if this is a statement or a question. HOA member goes through the process and pays the fine. When amending your governing document, is it worth it to include Kaufman language if you don't already have it? Specifically, if you don't agree with some of the new legislation?
Yeah, this is a sore subject for me, because I've probably spent the better part of the last 15 years of my career putting Kaufman language in documents, and I'm immediately regretting it. At this point, I don't recommend general Kaufman language. I think this, again, something to talk about with your attorney when you're doing your documents. But I think the better strategy now is, instead of having a general statement that the law should apply as amended from time to time. And that's, by the way, what the Kaufman language is. We'll talk a little bit about attorney here because we've had a few questions about it. What Kaufman language really is, it's language in your documents that says that a statute applies as amended from time to time. And the reason why that's an issue is because in general, statutes don't apply to affect your contract rights. And because your declaration is a contract, if you have a new statute and the statute doesn't specifically say that it's retroactive in its application, then chances are it's not going to apply to the pre-existing contract. Now, there's case law, and again, this is kind of this would be a good topic for its own webinar. So Peggy, if you want to schedule something new for just this topic, but the general law is there's case law that says if the law is procedural or remedial in nature, it will apply regardless of whether you have Kaufman language. If it's substantive in nature, it will only apply if you have the Kaufman language. So to me, an example of the new legislation is they changed the 720 fining statute to say that the hearing has to happen within 90 days of the notice letter. That to me is a procedural change in the actual process. That's going to apply no matter what, whether you have Kaufman language or not. That's a change in the fining procedure. It's a procedural law that's going to apply. But for example, we talked about the parking issue. They changed the HOA law to say that you can't violate somebody for having their work vehicle or their personal vehicle if it's parked in their driveway. Well, if you don't have Kaufman language in your declaration and you have a commercial vehicle restriction on the types of vehicles that a person can park, then my opinion, and I think the opinion of most association attorneys that I've talked to, is that without the Kaufman language applying the statute as amended from time to time, that restriction, because it's a substantive restriction on your ability to enforce your documents, won't apply to you as a pre-2023, 2024 statute. So again, probably the type of topic that could take up an hour on its own, but the general idea of Kaufman language is, do you have language in your documents that says that the statute applies as amended from time to time? If you do, then these new laws are going to apply. If you don't, then some of them may apply, some of them may not, depending on whether they're procedural or substantive. And my recommendation, to get back to the original question, is I don't recommend putting general Kaufman language in anymore, because then you're automatically subjecting yourself to all the changes. My recommendation would be find the areas of your documents that you want the new laws to apply. Like, for example, you want to be able to charge, if you're an HOA, charge more than $100 per violation or $1,000 in the aggregate. So you might want to put Kaufman language in your fining provision to specifically say that you can levy fines in an amount as provided by Florida law as amended from time to time, and restrict it specifically to the fining issue, because that's a good law for HOAs as opposed to some of these other laws. So I think the strategy when working with your attorney is pick out the 5 or 6 areas in the documents where you want the law to apply to you, and put the specific Kaufman language as applied specifically to that provision. But I don't recommend any more of the general Kaufman language.
Okay. For a condo, if we need to have an attorney send a letter, can we charge the violator for the legal fee? I think you answered that already.
Yeah, again, I don't think you have the right to, unless the documents clearly provide it. But you know what? No harm, no foul in doing it. But send them a bill. Sometimes they pay it. Something, or you get into mediation, and maybe part of the mediation, the resolution at the mediation is paying the fees. We'll agree to give you 30 extra days to remedy the violation. You agree to remedy the violation, and as a condition of resolving the mediation, you pay X amount of our fees and costs that we've had to lay out for even being to this point. So again, that doesn't hurt to charge them, doesn't hurt to put it on their ledger, doesn't hurt to send them a bill or to try to use it as a bargaining chip in mediation. But at the end of the day, it's going to be harder to really force them to pay those fees if it gets down to it.
Okay. Continuation, 2 weeks later, violation starts again. What happens at the time or start all over again?
Yeah, if it's truly a new violation, then I think we start the process over again. But then again, you need to do a new 14-day notice with a new hearing, but then you'll be able to charge the $100 a day up to the $1,000.
Okay. If the owner is fined by committee on one item and accumulates the maximum fining amount, what happens if they don't pay and they're selling their unit? Are they forced to pay the association in order to sell their unit?
Hopefully that works itself out at closing, because chances are you're going to have an estoppel on the property, and the estoppel is going to list anything that's outstanding. So any unpaid assessments, any unpaid fines, any pending violations. Remember, the new owner is going to take title subject to anything that's pending on the property. So whether they work it out in closing, whether they reduce their selling price by 1,000, or whatever it is, chances are 90% of the time it works out at closing. But the bottom line is make sure you're working with management and with your board to have a proper estoppel. Make sure the estoppel lists anything and everything that's either a pending violation or that's due to you, because then that new owner will take title, and then you can go after the new owner for those violations and for those outstanding fees.
Okay. Can the fine be applied to a homeowner's account prior to the committee approving if the board has already voted to approve it, asking for estoppel which may be ordered during the time frame between board vote and hearing?
If it's for an estoppel, I think you can probably work the language out to say, pending potential fine. It's really not a fine until it's approved by the committee. So I would not, it's not collectible until it's approved by the committee. I wouldn't force the issue, but I don't know that there's any harm in at least pointing out the fact that there's a pending violation where the board has issued a fine. I think if we can wordsmith it the right way, I think we can get away with it. But again, forcing them to pay it, let's say the home closes prior to the hearing, that's not a fine that's I don't think it's going to be collectible because it was never officially approved by the committee. I don't think it's actually collectible until the committee votes yes at that hearing.
Okay. If the Kaufman language is one part of the declarations and on in the others, does it apply to all or just when it's in the docs?
It depends on how it's worded. If you're talking about a section that's talking about the ability to collect assessments, in accord, let's say it says we have the right to collect assessments in accordance with 720-3085 as amended from time to time. Well, that's Kaufman language as to 720-3085, not necessarily to the rest of 720. So again, depends on exactly how it's worded. But a lot of times there's just very general Kaufman language in the association's documents that just says that the HOA Act shall be defined as Chapter 720 as amended from time to time. If that's what the language says, and it's basically saying 720 applies as amended from time to time, I don't care where it is in the declaration, if it's on the front page or the last page or in the middle, that's Kaufman language, and that applies the full 720 to you no matter what it is. So, and that's the language that I think we probably want to try to avoid moving forward.
Okay. Outstanding information, Steve. Thank you. This is the best and most outstanding webinar on covenant enforcement that I've heard in the last 6 years.
Appreciate that.
And that I've been listening to Condo webinars. How soon after the fine committee agrees to fine the owner must the fine be paid?
It is now, it used to be 5 days. It's now 30 days, at least for HOA. It might still be 5 for condo. Something I can look up that offline if you want to reach out to me offline and I can confirm. But one of the new changes in the statute for HOA is now it's a 30-day. And what's interesting is with the HOA statute, again, this is solely HOA. They also changed the law to say that you can't collect the fine if the violation gets cured prior to the hearing or prior to the due date of the fine. Now that to me is one of those substantive restrictions, not a procedural restriction, because that's affecting your substantive ability to collect on your fines and to enforce your documents. But that's something to keep in mind now as an HOA moving forward. If I set the hearing and the person decides to basically cure the violation prior to the time of the hearing, depending on whether or not you have that Kaufman language, you may not now be able to go and collect that fine as an HOA because of that new statute. So that's, there's several of these new laws that are going to be a little tricky and dicey for our HOAs.
Okay. Does the board have to vote to levy a fine for a particular homeowner?
Great question. 99.9% of the time, I will tell you that any decision of the board needs to be done at a board meeting with proper notice and so forth. So yes, in theory, the statute says the board shall levy a fine, which means the board needs to take action. What really happens most of the time is the board delegates a process, usually to management, and can delegate the violation letters and can delegate based on a fining schedule. If you have a board resolution delegating authority, you can work with your council to put this together. But you can delegate authority so that management can just kind of roam the property, identify violations, send out violation letters. And if you have a fining schedule that sort of presets the amount of the fine for certain types of violations, if you do a proper delegation, you may be able to avoid having to go back to the board every single time you want to levy a fine. But the bottom line is the statute says board levies the fine, committee approves the fine as levied by the board. So that implies 2 specific actions: board action on the front end, committee action on the back end. And I think that both have a formal process. The board action does need to take place at a proper board meeting, and the committee action does need to take place at that committee hearing on the 14 days notice.
Okay. What happens if the violation is cured before the hearing?
If you're a condo, it doesn't matter. If under condominium law, they didn't change that. So if the fine is cured prior to the hearing, that's great. You can still have the hearing. You can still fine them for the violation. At that point, the committee might decide, you know what, no harm, no foul. They cured it, so we're not going to vote in favor of it and penalize them. That's up to the committee. They can vote yes or no, and the person can plead their case. As an HOA, it's going to depend, I think, on whether you have Kaufman language. If you have that Kaufman language that applies the statute as amended, and the person cures the violation before the hearing, then what the statute now says is that you cannot impose that fine if they've cured prior to the hearing. If you don't have the Kaufman language, then I would argue that you still have the right to pursue the fine.
Okay. What exactly changed for the fining in the updated statute? Do they now have 30 days to pay the fine? If they don't pay the fines after the deadline, what recourse does the HOA have to collect?
So yes, one of the changes is that they now have up to 30 days to pay the fine. That's the due date. You have to hold the hearing within 90 days of the notice. A couple of other minor procedural things. I don't have the statute in front of me to have them all listed out, but there are a few minor statutory changes this year on fines. The bigger issues are things like they put in, and again, this is for HOA, they put in the restriction that you can't fine for certain types of violations, like leaving your trash out either 24 hours before or after the scheduled date of pickup. You can't now fine for leaving your holidays lights up if it's less than, I think, 7 days after the demand to put them away. So if you have a restriction that says the holiday lights can only be up from a certain time to a certain time, you have to wait. You have to send a letter first after the deadline, and then you have to wait another 7 days before you can levy a fine. So they've made some adjustable things like that. The trash thing is a little silly. I mean, it's kind of funny, but it's a little silly in that they say that you can basically keep your trash out 24 hours before or 24 hours after a scheduled pickup. Well, I'm not sure if they thought this through and realized that there's usually two scheduled dates of pickup during a week. So if my pickup date is Wednesdays and Saturdays, and I can leave my stuff out on the Tuesday before, the Thursday after, that also means I can leave it out the Friday before the Saturday pickup and the Sunday after the Saturday pickup. So does that mean I can only fine on Mondays if I've left the trash out on Monday? I mean, it's a little, I mean, it's kind of silly what the effects of these laws are sometimes because they don't really think them out. But again, bottom line is they made some changes to HOA statute. You're really going to want to consult with your counsel, especially when you're talking about vehicle restrictions, because they hit that hard this year. Fining for trash violations, fining for holiday lights, they've hit those issues this year. They put something in that says that now, if as an HOA, if you have a restriction that says if a person that's looking for approval of work that they're doing on their home, you can't condition that on the contractor being licensed. I mean, some ridiculous stuff, but there's some things that you're going to have to deal with your association's attorney when you're moving forward with trying to enforce some of these covenants. And again, whether or not you have Kaufman language, because then it all comes back to, are these substantive changes that will only apply moving forward, or are they procedural changes? And I think all of these violation-related changes in the law are substantive. And most of the people that I've talked to are taking that same position, that the change in the vehicle statute, the change in the requiring licensed contractors, the change in the fining for certain violations, those are all substantive changes in the law that affect your ability to enforce your covenants. That to me won't apply to you if you don't have the Kaufman language.
Okay. Do fine hearings letters need to be sent certified?
They don't. They only need to be sent by mail, but my recommendation is send them both. Send them certified so that you do have a record if they do get picked up, but also send regular mail, because under Florida law, if you send by regular mail, it's deemed to have been delivered. Any of my violation letters, I always send both certified and regular mail.
Okay. Is the condo association responsibility to fix windows, glazing, sills, casing, and hardware that are original construction?
Depends on the documents. So I can answer that with a definite maybe. How's that?
If a homeowner changes via resale, no estoppel is ordered, and the new owner is not yet updated in the management system, title company delays, can you still levy a fine and transfer it to the new owner?
That's going to be tough if it's not on an estoppel. I think they're going to have an argument that they weren't put on proper notice and that the fine's not going to be collectible. The bigger question is going to be, is the violation, if they were issued an estoppel and I didn't list the violation, that could be a problem for you as well. If it's just that they didn't get an estoppel, we may still be able to pursue them for the underlying violation. But I would say that you would have to, at the very least, start over the new process with a new 14-day notice and a new hearing if you want to try to collect any fine on a new owner.
Okay. Can the cost of the certified mail be billed to the violator?
Again, similar to the attorney's fees, you can throw it on the ledger, you can make a demand for it, but at the end of the day, it's probably a cost of doing business that you're going to have to take care of as an association.
Okay. That's all. We're caught up on questions.
All right, so we've talked about the ways to enforce the documents. We've talked about all the different remedies of enforcing the documents. What happens if we haven't been enforcing it? That's sort of the next step in the process is, what are the pitfalls for enforcement? What happens if we've stopped enforcing but want to start enforcing again? What happened? Are there any arguments against our ability to enforce the documents? What are the defenses to covenant enforcement? And there's a bunch of them, but really I think the two biggest ones that I want to talk about: statute of limitations. There's a 5-year statute of limitations on covenant enforcement. So if somebody's had their violation and it's been out and obvious for more than 5 years, you're not going to be able to enforce that provision on them because of the statute of limitations has run. It'd be an easy motion to dismiss. You're going to wind up having to grandfather them and move forward. The other big one, of course, is selective enforcement. What happens if we have been lax in our enforcement, but now it seems like a whole bunch of people are coming forward with new violations? What do we do to put ourselves in a position to be able to enforce our documents moving forward? So selective enforcement, basically that means we're sometimes enforcing, or we've enforced in the past, but then we stopped enforcing, but now we want to try to enforce again. Or maybe it means we've enforced some parts of the documents, but maybe not other parts of the documents. The bottom line on selective enforcement is it's an apples to apples analysis. You can't sit there as an owner. If I'm an owner and I'm violating the pet restrictions of the documents, and I know that the association hasn't been very good at enforcing its vehicle restrictions, I can't turn around to the association and say, hey, that's nice that you sent me a letter about my Rottweiler, but you haven't been enforcing your parking restrictions, so you're selectively enforcing the document, so I don't have to comply. That's not how selective enforcement works. It's apples to apples. So that means if you're citing me for a pet restriction, then my selective enforcement defense is only if you haven't been properly enforcing, or if you've been selectively enforcing your pet restrictions. It has nothing to do with the other restrictions in your document. So selective enforcement, again, if somebody's raising that defense, they need to be showing that you've selectively enforced that same specific provision that you're trying to enforce on them. Now, let's assume that either the statute of limitations has run or that you have been selectively enforcing and they have a good argument. What do we do now? Have we completely lost our ability to enforce the documents forever? And the answer is no. There is actually a mechanism for you to be able to put your documents back in place on a moving forward basis. I call it cleaning the slate. I think there's a specific case law site to it that other attorneys use, but I like the term clean the slate because that's basically what you're doing. You've lost your ability to enforce a provision. You want to clean the slate and you want to move forward and be able to enforce it prospectively. And the way you do that is basically you grandfather the existing violations that you have to grandfather. You grandfather the selective enforcement, you grandfather the statute of limitations. You put people on notice that, hey, if you have this violation that's prior to this date, we're going to allow you to continue to have that. We're going to allow you to have the non-conforming fence or the non-conforming vehicle or the pet that weighs over 30 pounds or whatever it is. But moving forward, this is notice to the whole community, and you send this out in a letter to the whole community. Moving forward, this is a republication of this restriction. On a moving forward basis, we are enforcing this restriction vigorously. So any new fences have to comply with whatever our fence standard is. Any new pets can't be over 30 pounds. Whatever the restriction is that you've lost the ability to enforce, you can republish that restriction. You just have to grandfather the existing restrictions. Now, the important point, and then we'll go to some of the questions that are popped up. The important point on grandfathering is it's the violation that gets grandfathered, not the person. That doesn't mean the person gets to forever have a fence that doesn't comply. It means that that particular fence gets grandfathered. But if a hurricane comes in and blows down that fence and they have to rebuild their fence, since you republished that restriction properly, they have to rebuild that fence with a proper fence that conforms to your restrictions. Or if the dog dies, you have a no pit bull provision. They have a pit bull that they brought in, it's been grandfathered, but now the pit bull dies and they want a new pet. Now they have to get a pet that complies with the current restrictions that you've republished. Whatever the restriction is, whatever the grandfathering is, applies to the restriction itself, not the person. They don't get grandfathered forever. Beth, we got some questions?
We do.
Okay.
So for condos, if the association is responsible for the drywall repairs inside the unit, when the association document says it's the homeowner.
That's not exactly a covenant enforcement question, but the general answer on that is it depends on if the damage is based on an insurable casualty or if it's normal wear and tear. And Beth, you could probably answer this even better than I could, but the bottom line is if we're talking about a hurricane or a sudden burst pipe or something that's an insurable casualty event, then under the statute controls, regardless of what the documents say, and what the statute says is that the whole of the condominium property is the association's responsibility, except for, and it carves out certain exceptions for what's not covered under the association's insurance. So drywall, by being part of the condominium property that's insured by the association, if it's an insurable loss, then yes, regardless of the documents, the association will be responsible for drywall. If it's just general wear and tear or general maintenance, then you look at the documents. It depends on what the documents, what the boundaries of the units are and what the maintenance responsibility is under the documents.
If an individual has several different violations, can we charge up to $1,000 for each violation, or is there a one-time $1,000 violation?
Yeah, the limits to me are per violation. So if you have $100 per violation, up to $1,000 for a continuing violation, and I've got 3 different totally separate, unrelated violations. I haven't painted my home properly. I've got a commercial vehicle on my property, and I've got a non-conforming dog. Let's say I've got 3 violations that are continuing in nature. Then yes, you can do $100 a day up to $1,000 for each of them. So you could, in theory, have $3,000 worth of fines after 10 days, in theory.
Association versus unit owner responsibility, 718 statute says that the condo is responsible for the windows, glazing, sills, casing, and hardware that are original construction.
Yeah, but I believe that is under the insurance statute. So that's correct. But I still think you look to the documents for just general wear and tear.
Okay, with selective enforcement, how do we handle the complaint that others have parked in the street? So their violation of parking in the street should not be fined. As an HOA, we cannot be everywhere all the time. We are a small board, 4 people
Yeah.
who are responsible for monitoring the neighborhood for violations.
Yeah, and that's a tough one. I mean, it's not like a fence that's sitting out there in the open for a year where you've driven by it. And there are going to be times where people park in the street. They come in late at night. They're gone by the morning. You didn't catch it. So I mean, you do the best that you can. I think that courts will be a little forgiving if you can demonstrate that you're doing as diligent a job as you can. But look, anytime somebody responds to one of my letters saying, okay, thanks for your violation letter, but did you notice the other 10 people that do the same thing? My response to that is to forward that back to the association and say, hey, send 10 violation letters to independently check this out, make sure that they're not, full of it. But if you have other violations and maybe you didn't catch them, you still have the opportunity to go back out and send violation letters to those other people. So that doesn't mean just because you didn't catch it right away that you've selectively enforced. There's a reasonableness standard to this. There's a due diligence standard. As long as you're acting in the best interest, as long as you're acting prudently and reasonably, and you're doing the best that you can, and you're trying to catch as many as you can, there's certain types of violations that you're never going to be able to catch every single one of them. So do the best you can, and you just deal with it on a case-by-case basis.
If the HOA association is preserving their governing documents for MRTA, would that clear the issue of non-enforcement of violation rules?
Great question. I actually have that marked down to talk about the Marketable Record Title Act towards the end, and I guess we're getting towards a little past 11 o'clock, so we can wrap up soon. But that is one of those unique issues for HOA. So for those of you that have no idea what we're talking about, the Marketable Record Title Act, and this applies HOA only, so this is not a condo issue for you to worry about. But for HOAs, if your documents are coming up to being 30 years old, there's the potential that your documents, it's not so much that the documents expire, it's a little more convoluted than that, but the bottom line is if your documents are getting up to being 30 years old, there's the potential that you might lose the ability to enforce the documents in your community. So the Marketable Record Title Act has a process of preserving the documents prior to the 30-year dates, where basically the board just holds a meeting, votes to preserve the documents for an additional 30 years, and then records a special notice in the public records of the county, and then you're good for another 30 years. If you've gone past the 30 years without preserving, you might need to conduct a vote of the owners to what's called revitalize the documents. It's a majority vote of the community. You can revitalize the documents. I think the question is asking if we've gotten to that point where we've lost the ability to enforce because of the Marketable Record Title Act, then I think you're back in the same position that you are with selective enforcement or with the statute of limitations. Once you've revitalized the documents, I think at that point you just do a clean the slate moving forward and say, hey, we're going to grandfather the existing violations that we lost the right to enforce because the documents expired under MRTA. We're going to grandfather violations that we couldn't enforce previously, but we're republishing the documents. We've revitalized the declaration. Moving forward, this is what the rules are going to be. And I think you just deal with it that way.
Okay, there's like a 3-parter. There's a crack outside my windowsill where the rainwater runs through down the wall to the kitchen wall of the first floor unit. My window is fine. I never get rain inside my kitchen. The crack should be fixed by my condominium association. I don't have to repair my window.
So again, if it's a crack in the exterior that's due to the wear and tear of the building, as chances are the exterior of the building is a common element. Chances are the documents will say that the common elements are the responsibility of the association. So you probably do have a good argument that the association should be responsible to fix the crack. But again, it depends on exactly what the nature of the water intrusion is. You might need to hire an expert. I think this is probably more of a question that's not really for this particular seminar. You might want to contact either me or another attorney offline afterwards to talk it out. But yeah, if you're telling me that there's a crack in the exterior and it's not an issue with the window breach, then you may have a good argument that it's the association's responsibility.
In a COA, does the board of directors have to have a meeting first before going to the finding committee?
It's not so much that you have to have a meeting. You have to have a meeting to levy the fine, but it's not so much that you have to have a meeting to discuss the issue or to deal with enforcement prior to sending the notice of the hearing. I think the bottom line is if you have a violation, you have a number of remedies. You can send a violation letter, you can levy a fine and send it to the committee, you can turn it over to the attorneys. But whatever you decide, you should either decide it as a board at a board meeting, or you should have some sort of delegation of authority to management to be able to operate the violation process and deal with the attorneys directly.
All right, well, all caught up.
Okay. Well, I actually covered most of everything that was on the list. We've gone through the defenses. We went through the different types of remedies. We talked about the Kaufman language. So again, that's kind of at the end of my outline here. But the bottom line on the Kaufman language is we have some new statutes out, both condo and HOA, although really the HOA statute is the one that's got most of the changes on the enforcement issues. On a moving forward basis for HOAs, I think it's very important to consult with your attorneys to make sure, number one, do you have the Kaufman language in your documents? And if so, how broadly does it apply? And then number two, assuming you have that language, which of these new laws are going to apply to you? Which of them aren't going to apply to you? What can we do in terms of amendments to give us the best chance of being able to enforce our covenants or to avoid these issues? I think those are the discussions that you need to be having with your attorneys and having them review your documents to see where you're at. Any last questions or any last comments? Oh, the MRTA process at 2 to 3 years prior. Yeah, I think you should start with at least 1 to 2 years prior, maybe 3 years is fine. Understanding that when you do it, you're renewing for an additional 30 years from that point. So I've had some clients do it 10 years early. That doesn't mean they get now 40 years more on their documents. It's 30 years from the point that you've reserved. But it's never too early because you don't want to put yourself in a position where you've accidentally gone too late. So
There are a couple questions that are in the chat,
Okay.
Steve. What exactly changed for the finding updated statute? They now, well, I think that one was asked on the
we
chat.
talked, yeah.
Yeah, what do you do when the president of the board and their family do not comply with the community rules?
It's called a recall. Majority of the community no, I mean, look, it's selective enforcement, right? You can't be an officer or director and take benefits and apply the rules differently to yourself than you do to the rest of the community. So your options are hire an attorney to sue the board or try to do a recall. And again, this is against my own financial interest, but I always believe that if you have issues with your board members or your president or whoever, always easier if you can get community support to do a recall as opposed to trying to hire a lawyer, spending money and filing lawsuits. So if you have out of control board members or if you have board members that are taking benefits, the real answer to that is get new board members in.
Okay. Can the COA enforce violation for placing decorative items in common areas if it's an American flag?
Ooh. Where's that question? I want to read that again.
Yeah, that's under question Q&As.
I was under Q&A now. Sorry, I was in the chat. All right, can a condo, is it condo or HOA enforce the violations placing decorative items? Well, I would say if it's an American flag, I think that's protected. There are certain types of flags that are protected by statute, and it's a little bit different between condo and HOA. But there are certain types of flags that are going to be protected as long as they're done in a respectful manner and as long as they comply with statute. Beyond that, I think it's going to be dependent on whatever your documents provide for. So, for example, with HOA, you're allowed to fly, I believe now it's up to 2 flags, and it could be the American flag, any of the flags of the armed forces, the POW MIA flag, or now they've added flags of first responders, whatever that means. So I assume that means police and fire rescue and so forth. So those are the protected flags. Now, if somebody wants to fly the flag of Israel because they want to support what the Israel or whatever it is, or they want to fly a flag of the Florida Gators, which I'm not sure. And I'm a big Gator fan, but after this last weekend, I'm not sure anyone's doing that right now. But whatever it is, whatever your flags are, that's going to be entirely dependent on your documents. But if your documents don't have restrictions, you can't pick and choose and say, well, we don't want the person to fly this particular flag because we don't like it, but we're okay with them celebrating a particular football team or whatever. So you got to that's where the selective enforcement is going to come into play. But I think to answer the question under 718 and 720, if the flag that they're trying to fly is one that's listed under the protected flags that they have an absolute right to fly, then it doesn't matter what our restrictions say. They have the right to fly those types of flags.
What about the appeal to heaven flag? A resident claims this is a military flag.
Not familiar with that flag, but the way the statute, at least I recall it being worded, it says a flag of the armed forces. So to me, that means Army, Navy, Air Force, Marines, Coast Guard. It's got to be an actual official flag of those branches of the military.
Okay. Do parking violators still get to cure the violation before the hearing? Are short-term violations not curable? If a car parks in the street all night against the declaration and they move it, can you still send a violation?
Yeah, in that situation, I would say yes. And again, to me, the way the statute's worded is if they've cured the violation prior to the hearing, well, what's it mean to cure? If there are certain types of violations, to this person's point, that probably aren't curable. If there's a type of violation that's a one-off type of violation that's not curable, then I think you absolutely have the right to pursue that violation, pursue that fine, and levy that fine.
Okay. I think we're caught up. A lot of great presentations, best on the subject in 25 years. Fantastic. Great job, Steve.
Very cool. Well, thank you. And again, appreciate the opportunity, and thank you to all the sponsors and to you, Beth, and Peggy and everybody else for having me.
You're welcome. I told you you have a big attraction. Great job. Absolutely great job. A lot of information for the new board members. This is recorded, so after this, I will be sending you the link to maybe listen again to, or maybe if you think there's some information others on your board need to hear and couldn't come today, feel free to share it. And I don't think there'll be any questions going out, but if you have any, Steven's information will be on the sponsor sheet. He'll be listed as number 1. How about that?
Right. Awesome.
I do want to mention a little bit of information that's coming up. On September 13th, CAI Gold Coast, which is in the Palm Beach area, is needing one more manager for their golf tournament. So if anyone golfs, the managers are free. So get on the website and you can find that information to register. CAI Southeast Group here in South Florida on October 11th is having another tournament. They are still looking for sponsors. So anyone interested in that, feel free to do so. That one does start at 7 a.m. So that's a little early, but if you're a golfer, you'll do it. So on September 11th, I'm having another webinar by Smith Engineering. He's going to cover a lot of information regarding Milestone, with also some extra information just in general regarding engineering and tips. Again, great information. I want to say good luck to the new board members who are being elected coming in. Don't forget you have that new law to comply with where you have to have 4 hours of education. Watch for the sponsor sheet. I want to say regarding the credits, I've had a couple questions come to me on an email, and I think one came through on the question and answers. If the credit today will apply to boards, and the answer is no. The board member credits are separate from the CAM credits. And on the CAM credit note, I just want to let you know that you need to allow a couple weeks to have your credits posted. And they will be posted in time for your end of the year renewal of your license. And I want to say congratulations to all of the new CAMs or CAMs that are renewing, and hats off to you for continuing your education. So thanks, sponsors. Looking forward to see you guys on the next webinar, and thanks, Steve. And we'll see you next time. Thank you.
Bye-bye.
Bye.